Welcome back. This is your second set of lectures on the law of thoughts. The first part covered the definition of the law of thoughts, and the second part we are going to look at the actual content of the law of thoughts. So, if you see the lecture notes, you have the law of thoughts under the thought of negligence. You have also special special liability regimes, and under special liability regimes we look at occupier's liability, employer's liability, product liability, and breach of statutory duty. And then we look at personal torts, interference with person, information of privacy, defamation. And then we look at land torts, trespass to land, and the rule actions under violence and Fletcher for damages. Right, negligence. Negligence is like the most common or the most popular sort of action in tort. It basically, the tort of negligence provides a remedy where injury or loss is caused to injured party by the wrongdoer's failure to keep a legal duty to take reasonable care. So if you were the a party that had a duty and then you failed to take reasonable care, and then as a result, another person, because of your negligence, has suffered injury. So some classical examples is a cyclist is knocked down and killed by a speeding car. A junior doctor mistakenly injects the patient with the wrong antibiotic, causing permanent paralysis. Injury in the above examples you see is the fault of someone apart from the injured party. They may be liable for the tort of negligence. We say they may be liable because of the fact that only a court can impose liability, or unless someone accepts liability, and that's where the liability can be accepted. All right, the sort of famous case that happened in 1932 that established the principle of negligence and the duty to take reasonable care is a case titled Donahue versus Stevenson, 1932, UK EEL reports, or Appeals Court 562. So this is the case that gave birth or re-emphasized and strengthened the thought of negligence. So in this case, this lady, Miss Donahue, goes to a cafe where she buys a ginger beer in a glass bottle, and then on the ginger beer was the name and address of this guy, D. Stevenson, the company making the beer. So Miss Donahue goes to the cafe, buys the ginger beer, opens the ginger beer, and consumes the ginger beer. Once she consumed the ginger beer, after that, she noticed that there was a decomposed snail floating over in the ginger beer, and she was shocked, and she had a subsequent illness. So then she tried to claim damages through basically the courts, and she sued under the general principles of negligence and the principles of duty of care. So the issue that went before the court, as you can see in the slides, was whether the defendant owed duty of care to Miss Donahue despite no contractual contract. So it's like a manufacturer of ginger beer. Does the manufacturer owe a duty to the consumer, and was there a duty of care? In the judgment, the case was decided in favor of Miss Donahue, and the case basically stated that the defendant owed a duty of care. The person making the ginger beer drink, owed a duty of care to the person consuming it, which was Miss Donahue. And that snail, a decomposed snail, was not supposed to be in the ginger beer. Basically, the case of Stevenson Donahue is a landmark case that establishes the principles of duty and care, and it laid the foundation of thought of negligence. Regardless of the absence of a contractual relation between parties, a duty of care arises. So in that judgment, Lord Aitken was a judge in that case, and basically he said that as a manufacturer, the product owed a duty of care to the consumers. So basically it means that if the consumers consume that product and it was not in the rightful quality and state it's supposed to be, that means that you owed a duty of care. So in that case, they ordered the company to pay Miss Donoghue $200, and in today's world, it would be roughly equivalent to about $12,200, or in PNG would be 36,000 kina. In that case, there was a famous principle that Lord Atkin, one of the judges, raised. So in the olden days, in PNG now we call them judges. In the olden days, they were called lords. So Lord Atkin, Lord Denning, all these judges. He's basically said that in role of in establishing negligence, there is the neighborhood principle. So the neighborhood principle was drawn from the biblical parable of the Good Samaritan, and it becomes a principle as the neighborhood principle. So in law, who is my neighbor? Any person who was so closely and directly affected by my act that I ought to have reasonably to have them in contemplation as being so affected when I'm directing my mind to the acts and omissions that I call into question. So basically, you must act with reasonable care to avoid acts or omissions which you can reasonably foresee would likely to injure your neighbor. So neighbor is any person that is going to become directly in contact with my act. So for instance, if I'm cutting grass in a joint property and my neighbor's vehicle is parked on the other side, uh, I know that the grass cutter that I'm using has this tendency to propel stones flying in all directions. So I must take the reasonable duty to ensure that either I cut the grass when the car is not there, or I clean up the yard, rake it out properly, and remove all the stones, and I cut the grass, or I put a block across the portion that I cut the grass to block any debris, any stones, any metals from being dispersed in the direction of the window of the car. So Donovan Stevenson basically said that you have a duty of care to everybody that's going to be affected by your actions. So in that case, the uh, manufacturer of the ginger beer had to ensure that the ginger beer was of good quality, and a snail in the ginger beer is the fact that they have breached the duty of care. So the duty of care is a core ingredient in the course of action for negligence. Examples of duty of care there: an employer owes a duty of care to the employee to provide a safe place of work, system of work, plant and equipment, and a occupier of a premises owes a duty of care to the entrant. For example, stop and shop stores or maju should not be slippery, so that whenever any person coming onto the property will get injured. All right. So for a duty of care, that is what we mean.